Okay, let's get right into it. We're talking about one of the most stressful parts of moving, getting your security deposit back. It can feel like your landlord has all the power, right? Well, what if I told you that in Florida, the law has a secret rule book that actually puts you in the driver's seat? We're going to walk through it right now.
So, you've packed the last box, you've done the final sweep, you've handed over the keys. That sigh of relief. But then, almost immediately, that little voice creeps in. Am I ever going to see that deposit money again? It's a super common fear, but you'll be surprised to know that Florida law is actually on your side here.
So where does this power come from? It all boils down to one law, Florida Statute 83.49. And you got to understand, this isn't a friendly suggestion for your landlord. It's a strict, non-negotiable timeline they absolutely must follow, and it starts the second you move out. Understanding this timeline, well, it's everything. From the moment you're gone, your landlord is officially on the clock. But here's the thing, it's not just one clock. There are actually two different deadlines they could be facing, and you need to be watching both of them. Okay, so your landlord has two paths they can take. Path number one, it's simple. They give you back your entire deposit within 15 days. No fuss, no muss. Path two is where it gets a lot more serious. If they want to keep even one single penny, they have 30 days to send you a formal notice of claim. And, this is key, it has to be sent by certified mail. Not a text, not an email, not a phone call. Certified mail, because that creates a legal paper trail. Let's look at your countdown. Day 0 is the day you hand back those keys. The clock starts ticking now. By day 15, you should have your full deposit. If you don't panic just yet. The real date you need to circle on your calendar is day 30. That is the final, absolute, no excuses deadline for your landlord to make a legal claim on your money. And that brings us to what the source material calls a tenant's legal superpower. This power gets triggered when a landlord is late or sloppy or just completely forgets about that 30-day deadline. The legal term for this is absolute forfeiture, and it means exactly what it sounds like. If your landlord misses that 30-day deadline to send that certified notice, they forfeit all rights to your deposit. I'm serious. It doesn't matter if you left a giant hole in the wall. The deadline is absolute. They lose their claim. I'm going to say that again because it is so important. The source puts it perfectly. They forfeit the right to keep a single penny of your deposit. The law is that strict. For a landlord, missing that 30-day clock is a huge and very expensive mistake. And look, this isn't just some dusty legal theory. This has real-world consequences for real people. Let's take a look at a case that involved this exact amount of money, $2,500. So here's how it went down for a renter in Orlando. They moved out on January 1st. Day 30 came and went, silence. On February 1st, which was actually day 31, they still hadn't heard anything. So they sent a formal demand letter. You know what happened? The landlord's lawyer immediately saw the mistake. They knew their client had blown the deadline and had no legal choice but to refund the entire $2,500 deposit. See, this law really works. Okay, but what happens if your landlord is on top of their game and they send you that notice within the 30 days? Well, as soon as you get that certified letter, the ball is officially in your court. A new clock starts ticking, and this time it's for you. The process on your end is super straightforward. Once you get that certified notice in the mail, you have exactly 15 days to formally object to their claims, and you have to do it in writing. And how should you send your objection? You already know the answer, certified mail. You need that paper trail to prove you met your deadline. Now listen up because this part is critical. If you don't respond, your silence is legally considered agreement. If you get a notice of claim and you just ignore it for 15 days, the landlord can legally take the money they listed. You lose your right to fight it, so you have to take action. All right, let's bring it all home and do a quick recap of the essential things you need to remember. Knowing this stuff can literally be the difference between getting all of your money back or getting absolutely nothing. Here's the cheat sheet. First, your landlord is on a clock. Either 15 days for a full refund or 30 days to send a claim. Second, that 30-day deadline, it is absolute. If they miss it, they forfeit the whole shebang. And finally, if you get a claim, your own 15-day clock starts. You must object in writing and send it by certified mail to protect your rights. So you see, that power dynamic isn't what you probably thought it was. The law gives you the tools, it gives you the timeline. The only question left is, now that you know the rules, are you going to be watching that clock?